in the case. In the petition filed in the Bombay High Court, the Law Minister of India was respondent number 1 and the Government of India was respondent number 2. Both of them filed transfer petition for transfer of the writ petitions from the Bombay High Court to the Supreme Court under Article 139A of the Constitution. That is how these writ petitions came up for hearing before the 7 judges bench of the Supreme Court. Upon hearing the arguments, they declared the primacy of the CJI's recommendation on judicial appointments and transfers can be refused for cognate reasons. However, this judgment was presented by many on the grounds that it violated the independence of judiciary, which itself is a basic feature of the Constitution as held in Keshwananda Bharti case. In 1993, again writ petitions were filed in the Supreme Court for filling the vacancies in higher judiciary. This writ petition brought into reconsideration the controversial judgment in S.P. Gupta case. This is known as Supreme Court Advocates on Record Association versus Union of India or 2nd Judges case. The case considered 2 questions: the primacy of the opinion of the Chief Justice of India with regard to the appointments of judges to the Supreme Court and the High Court, and with regard to transfers of High Court judges or Chief Justices. And second, justiciability of these matters, including the matter of fixation of the judge strength in the High Courts. In 2nd Judges case, the Supreme Court held that in the matters of appointment and transfers of judges, the role of the Chief Justice of India is primal in nature. The Chief Justice of India must take into account the views of 2 senior-most judges of the Supreme Court. However, doubts arose about the interpretation of the law laid down by the Supreme Court. The President was reduced to only an approver. Therefore, exercising his power under Article 143 of the Constitution of India, the President of India made a special reference to the Supreme Court in 1998. Arguments in S.P. Gupta case. The petitioners challenged against the validity of the circular letter, which required the additional judges of the High Courts to give their consent for being appointed as judges outside the state. They argued that such consent in advance would reduce the consultation with the CJI, the Chief Justice of the High Court, and the Governor of the state to an illusory and empty formality. Other than their own, they may not be appointed as permanent judges at all, would be to introduce an irrelevant qualification for the appointment of a judge.